I would like welcome to myself to give the presentation.
Thank you so much. Thank you so much. So everybody, good afternoon. How are you all?
Great.
Hey, and my name is Farhad Sethna. I'm very honored to be here. I've done this for many years in the past, thanks to the Office of International Programs, and I want to thank them again. And I especially want to say that it's a pleasure and honor to be back at Akron U Business School because I got my MBA from here. And I also got my law degree from right across the tracks over there. And in fact, we've got also with us here Professor Elizabeth Knowles, who is one of the clinician professors of law. I've got one of my law students here as well, Carrie Hill, who's here as well, and I'm very grateful. And I've got a law student from a couple of years ago who came back to suffer through another one of my lectures. So I'm really very grateful that everybody's here. Thank you for being here this afternoon. We've got our Office of International Programs employees here as well, who have given you all a lot of information in the past. I know that you had a very good program on OIP and CPT, which was just a few weeks ago, so you all learned from that. And we've got information on that as well if you need that later on today in the Q&A session. So having said that, let's get into essentially the essentials of employment law and focus on what you're doing. Now, all of you are here, and by show of hands, I want to see how many of you are F1 students. How many of you? Just F1 students. So majority are F1. Anyone who's a J? No J students. Okay, great. Well, that's nice. Is it just me or is it very warm in this room? It is warm, right? It is warm in this room. Okay, all right. So if anyone wants to take off their coats and relax, hang it up behind your chair, that's perfectly fine. I might do it myself in the next few minutes. Okay, it is very warm in this room. So what I want to do is this today. Okay, we are going to talk about essentially a number of points, a number of things going forward, and what are some of those things we're going to be working on. We're going to be working on essentially working on making this computer work. There we go. We're good. Okay. What are we going to be doing today? Today, we are going to be looking at various issues. And some of those issues include general immigration. It's not specific. I want you all to understand that. It is not intended to be legal advice. I have to give you this disclaimer. I'm here to help you today to give you a broad overview of the immigration process. I'm not here to give you individual advice on a specific case. I'm not here to market myself. That's not my goal. My goal is to give you information. I'm going to have this presentation up as a PowerPoint and as a YouTube video on my immigration channel, which is US Immigration Guide. So you can pass that link on to people, and I'll be giving that link over to Ms. Leong, so she can then pass it on to other people, all the attendees, etc., because I know she has an email list. So we're going to be talking about a lot of things today. Please do consult, however, for your own case, a qualified attorney. Please do not try to do this by yourself or use what I am saying as legal advice for your specific case, because it's not. Every case is different, every person is different. Yes?
I asked Leila if she would check to see if there's a clicker.
There's a clicker. Thank you so much. I appreciate it. Thank you so much. Okay. So today what are we going to do? We're going to talk about the employment-based immigration issues, and with immigration overview, just the different visa types. We're talking about hiring an alien. We're going to talk about the various statuses that you might have. CPT while you're studying, OPT after you graduate, H1, O1, TN, which is trade NAFTA, or L visa status. We're going to talk about immigrant visas. What's an immigrant visa? We're going to talk about the steps in the immigrant visa process that is getting toward a green card. If time permits and if question and answers allow, I may talk about the green card processes, the green card itself, and the process of naturalization, which is becoming a US citizen. But those last three steps we'll probably keep for later or for Q&A, if time permits, because I want to try to get everybody out of here by about 4:30. Okay, what are we going to cover today? We're going to cover the basics. We're going to cover regulations, laws, priority dates. We're going to cover maintenance of your status as F1 students. We're going to talk about families and dependents. We're going to talk about switching, changing your status, COS, not AOS, COS from non-immigrant to immigrant. We're going to talk about the H-1B visa, options that you may have if you can't get an H-1B, the perm process, the EB 1, 2, and 3 categories. And we're finally going to talk about recent developments and changes. What's happening with USCIS, what's happening with the presidential executive orders, things of that sort. So it's all going to be very timely, very helpful information. Okay, other things that you need to be aware of. We're going to talk about typical routes to immigration. For example, an immediate relative, family-based immigration, employment-based immigration, asylum, investor visas, religious workers, U visas, T visas. We're going to just touch upon those topics as we move along. We're going to talk about priority dates and what they mean. Does anybody know, by the way, what a priority date is? Does anybody know? Excellent, you know, very good, excellent. We're going to call on you later, sir, okay? Be prepared. We're going to talk about visa expiry versus your I-94 expiry. Now, some of these already may have been covered in the OIP presentation on CPT, OPT, etc., but we'll cover them again. Okay, and we've got experts, as I said, from your OIP right here who can answer some of those questions toward the end. Okay, so let's talk about non-immigrant visa types. Many of you here are already on F1. What's an F1? Student visa, right, very good. Okay, what's a J1? Also for studying or research, right? Research scholar, correct? Okay, so that's a J1. What's an M1? Anybody know? M1 is a student who comes to the USA for, you should know this, please, Dale. You are in my class. You as well, sir.
Yeah.
You should know this too. Okay, all right. So an F1, we know. J1, we know. And M1 is someone who comes to the USA for, let's ask OIP if they know. What's an M1?
Someone who's vocational studies.
Vocational studies. Excellent. Give OIP a hand.
Yeah.
You are a credit man for this university. Okay, so M1 is someone who's coming for vocational studies. CPT, OPT, we've talked about before, you've heard about it before. We're going to talk about H-1B. What's an H-1B? What's an H-1B? Anybody know? Work visa. Very good, ma'am. Exactly. H-1B is a professional work visa, meaning not someone who's unskilled labor, someone who's skilled, has at least usually a bachelor's degree, and as a consequence is able to work as a professional. H-2A. What's an H-2A? Anybody know? The A stands for agricultural. These are people who come in temporary workers, short time, in order to work in the agricultural sector. Maybe picking plants, picking vegetables, picking fruit from the trees, things of that sort. What's an H-2B? H-2B is temporary non-agricultural work. So they may be coming as restaurant workers, as chefs, as stable hands, what have you, okay? H-3 is a trainee visa, meaning someone's coming to the USA for a brief period of time simply to get training at a US company, to take that training back with them to their home country. The O1, alien of extraordinary ability in the non-immigrant context. So that's an alien of outstanding ability. Actually, they've got to follow the same guidelines virtually as the alien of extraordinary ability EB1. L1A or L1B, those are intercompany transferees. Keep all this in mind, okay, ladies and gentlemen, because L1A, L1B are wonderful, wonderful visas. Why? If your father, uncle, relative, or you yourself have worked overseas for a company for at least 1 out of the past 3 years, and that company has a branch in the USA, or daddy has lots of money and wants to open a branch in the USA, and you're his favorite son. Okay, he hopes. We hope so too. Okay, so then daddy says to you, here's a small loan of $1 million. Where have you heard that before? Okay, a small loan of $1 million is given to you, as was given to our president at one point in time. Okay, my dad never gave me a small loan of $1 million, okay? Would have been nice, I never got a small loan. You get that loan, you can start up a company in the USA. If you started that company, if you worked for that company overseas for 1 out of the prior 3 years, you may qualify as either an L1A, which is manager or executive, or you may qualify for L1B, which is an alien of specialized knowledge. So L1A, L1B, very helpful. Okay, the E, Treaty Trader Investor, another fantastic visa. It is for countries that have a treaty of friendship, commerce, and navigation with the United States. And E1 is a treaty trader, so someone can enter the USA to trade with another country on the E1 visa. It's a long-term visa. The E2 is a treaty investor visa, so that person comes to this country to invest in the USA. Maybe it's a smaller investment, it's not the $1 million investment which is required for EB5 investor visas. It's a smaller E1, E2 level investment, which is enough to start a small business. May not create 10 jobs, but maybe creating 2 or 3 jobs. With the E1 or the E2, those are wonderful visas, but they're allowed only for nationals of countries that have a treaty of friendship, commerce, and navigation with the United States. Everybody with me so far? Yes? Okay? Alright. Dependents must always remain in status. Your spouse, your children will have your status. There have been many horror stories. Thankfully, none of mine, not in my law firm. Many horror stories where the lawyer has extended the status of the H1 or the L1 or the E1 and hasn't extended the status of the spouse and the children. And you're wincing. You've heard of this, haven't you? Right? You've seen it probably, right? Okay? Yeah. So it's a terrible thing to happen, but dependents must also remain in status. Okay? Thank you. All right. Employment-based immigration process. So entry to the USA as a non-immigrant. You come into the USA as a non-immigrant, like you all are here on F1 visas, or J's, or H's, whatever. You get your OPT. If you're an F1, you finish your course of study, you go running over to the OIP. What do they give you? A pat on the back. They say, thanks for all that money you gave us. Okay? Have a safe trip home. Do they do that? No. What do they do for you? They give you something very valuable, right? What do they give you? OPT. Look, guys, don't be afraid to say something, okay? And if you say it loud, that's even better, because if you make a big mistake, then everybody knows and we all laugh. So don't be afraid of saying something loudly. I say something loud all the time. Okay, and most of the time, people laugh. It's great, okay? So what does OIP give you after you graduate? What do you get? OPT. What do you do with your OPT? You go out there and you try to find a job, right? Okay, so you come in as an F1, you get your OPT, you're still in F1, you then find a job, and the employer hopefully puts you on an H1B or some other work authorized status, because we know those H1Bs are also a problem. We're going to talk about that in a little bit. The employer will petition for you for an I-140, which is the employment petition for immigration. If that employment petition is approved, you then apply for adjustment of status. Not change of status, which is COS, but AOS, adjustment of status. Adjustment of status is the process by which someone who is a non-immigrant, be it an H1, F1, O1, P1, Q1, anything, alright, switches over to a permanent resident. Adjustment of status. You're not changing your status from F1 to H1. Those are still both non-immigrant statuses. You are adjusting your status from a non-immigrant to an immigrant. Okay, so that's adjustment versus change of status. Okay, and finally, you get your green card, which, by the way, is it green? No, it's not green. Okay, go to my website, you may find an example of a green card. Okay, but that's how it works. Okay, hiring a foreign national. So here's the process that you're all interested in. What is OPT, first of all? Let me hear it from you. What's OPT?
Optional practical training.
Yes, sir. Optional practical training. What does it mean? What does it mean in like simple terms? If you said OPT, someone may not know. Imagine you're explaining OPT to one of your friends who's just come over to Akron U to study and hasn't yet had a chance to go over to OIP. How are you going to explain OPT to this person? What are you going to say?
You can work on F1 visa.
You can work on an F1 visa, okay. And can you work at any time while you're studying? After graduation. For how long?
12 months.
12 months, sir. Very good. And if you're in one of those STEM programs, then what?
24 months.
24 months more, right? In other words, 1 year to start, and then 2 years more after that. So a total of 3 years. Very good. Excellent. That's what OPT is. Good job, all of you guys. Listen, none of you become lawyers, okay? Because I'll be out of business. You guys are all so good. Okay? So just, do what you're doing. You're doing it great. Let me do the law part. How's that, okay? Okay? All right, good. duration of OPT. Timing of OPT is critical. Why is timing critical? Because it's a small window, right? When can you apply for OPT?
3 months before graduation.
And after as well, right? By 30 days, okay? So there's a small window, just a small window. If you miss that window, what happens? The window closes, okay? And you got to say sayonara, right? Which in Spanish is goodbye till we meet again. Correct? Okay? Right. Very good. Okay, so changing status. Yes, sir.
Let me clear that. So you can apply OPT 30 days after graduation. That's a maximum.
Up to 60 days.
Up to 60. So it's 60 before and 30 days after, right?
90 before 60 days.
Okay, 90 before, 60 days after. There's our expert from the UIP. So 90 days before graduation and 60 days after. So you have a 150-day window to apply for OPT. You miss that window and you're bye-bye. Hasta la vista, baby. Okay, alright. So, changing status to H-1B. How do we do that? We're going to talk about that in a minute. What's an H-1B? An H-1B, as I said earlier, is a temporary non-immigrant visa for someone to work for a specific employer as a professional. It's not for someone who is unskilled. It's for professional employment. We're going to look at the H-1B in detail. What if there's no H-1Bs available? There's going to be some other statuses available. Why would there be no H-1Bs available? Because the H-1B is limited by statute. It's one of the very few non-immigrant visas that actually has a cap, a limitation on the H-1B. How many H-1B visas are available every year? Anyone tell me? 65,000, very good. In addition, there's a little more available for people who have an advanced degree from the USA. How many more? 20,000, correct. So you have 65,000 as the base for anyone who has a bachelor's degree, and then you have another 20,000 for people who have an advanced degree from the US. So if your advanced degree is from Tajikistan, too bad. You've got an advanced degree, finish up with your advanced degree in the USA in order to get part of that 20,000. Now, on top of that, there is also a waiver, an exemption for certain types of H-1Bs, people working for example, for a federal government agency, people working in a medically underserved area who are switching from J1, let's say, to H1, people are working for an institution of higher education like Akron U. So Akron U has no trouble hiring professors who may be F1s on OPTs or having H1s already, because they've got an unlimited supply of H1s for institutions of higher education, for certain research institutions, for certain institutions affiliated with institutions of higher education like hospitals who may be associated with a university. Those are not subject to the 65,000, 20,000 cap. So keep this in mind, everybody. If you are in a situation where you're in a degree program, let's say, that allows you to work for a cap exempt employer, you are actually very fortunate, because your application will not be counted as one which is going to be subject to the cap. Now every year that cap, 65,000 plus 20,000, has been used up in full. In fact, last year there were over 200,000 applications for those 85,000 visas. So you had basically like a 1 in a 2.3 chance of getting one of those precious 85,000 visas. That's pretty bleak, right? Okay, so what happens if you don't get one of those 1 in a 2.3 visa? You're going to go to some other status. If you're that good, that exceptional, maybe you qualify for O1 status. Maybe you qualify for L1 status. Or maybe, worst case scenario, I hate to say this, some of you may end up going back to school, getting a second master's, okay? Or starting on your PhD program, so you can maintain your student status and still keep looking for something else and hopefully get another period of OPT at the end of that other degree. Now, if you have a master's and you got your OPT, you can't start another master's and get another OPT, because you can get only one period of OPT for every level of education. Okay, so if you have a master's already and you have an OPT, don't say I'm going to get another master's and get another OPT. You get another master's, that's great, but you will not get another OPT. You'll have to go for your PhD program and complete that program in order to get your next period of OPT. Everybody with me so far? Okay? The good thing I can tell you is this: nobody's fallen asleep. The bad thing is, I've got many more slides to go. Okay? Alright. Okay. So, the H-1B visa, what is it? It's professional employment for up to 6 years, 3 years plus 3 years. It needs a minimum of a bachelor's degree and payment of the prevailing wage. It's very important. Ladies and gentlemen, go to my website. There's tons of articles there on the H-1B process, on the perm process, on immigration to employment, immigration to family. Please read up. Today is only a very basic overview of the process, okay? Go and read up on these things. Learn how it works. So you must be paid at least a prevailing wage. Prevailing wage was set into place by Congress in order to protect the US worker. So foreign workers don't come into the country, undercut the US worker, accept less money, and then take jobs away from the US worker. So that's what the labor condition application does. It protects the US worker. Premium processing. Premium process is a way where you pay the US government extra money in order for them to do the job that they're supposed to do anyway. Okay, that's how it works. So, with premium process, the US government is supposed to adjudicate your petition within 15 calendar days of submitting the premium process. So if you have an H-1B and you pay an extra $1,250, that's a premium process fee, the US government is supposed to take your application, take your money, and adjudicate your application within 15 calendar days. Most of the time, the US government is doing this. For H-1Bs, they're saying we're not going to take premium processing because there are tons of applications coming in at the same time. So they don't do premium processing for the H-1Bs. Once they start premium processing, they have another trick. They've got another trick too. Very clever, okay? What they will do is they'll take your money, they take your $1,250, okay, very quickly, okay? They're faster than lawyers at taking money, okay? They take your money very quickly. Stop that laughing. Okay, it's no laughing matter, all right? Okay, they take your money, and then what do? They send you on day 14, they send you a request for evidence. We need more information. And guess what that does? It stops the clock. That 14 days, oh, you're thinking, tomorrow I'll get my approval, tomorrow I'll get my approval. No, you got a request for evidence. And until you submit that request for evidence, the clock doesn't start again. And guess what? It doesn't start and have 1 day left. It starts and they get 15 days again. Okay? So that's how the premium processing works. So before you go running eagerly to give them your $1,250, think about whether premium processing is going to help you or not. Okay? Alright? Everybody with me? Everyone with me so far? Great. Okay, good. Now make sure we haven't lost anybody. Okay? Now, extension of H-1B. Yes, it's possible. As I said, H-1B is given for a maximum period of 3 years. Can be extended for another 3 years. Under the AC-21, or American Competitiveness in the 21st Century Act, the H-1B can be extended even longer based on essentially a pending application for either a labor certification or a pending application for an I-140 or a pending application where adjustment of status cannot be filed because the priority date for that particular person's country is not yet current. So H-1Bs can go on and on. I've done H-1Bs sometimes for people up to 12 years because the priority date has not come around yet. So we keep on extending the H-1B year after year. Okay. Cap and non-cap H-1Bs we covered already. The cap is 65,000 plus 20,000. There's an exemption for some people who are employed by universities, for example, or research institutions, or institutions that are affiliated to a research facility or institution of higher education. Okay, so we've got some exceptions, but not too many, but they're very important and significant, especially for people who want to start teaching or become researchers with an institution of higher education. Thank you. Okay, recent issues of concern. This is why this slide is in red. Now, am I smart or what? Okay, put this in red. Why in red? Because it's important. Okay, so there's a policy that USCIS used to have. USCIS is the agency that adjudicates your petitions, whether it's the application for CPT or whether it's the application for H-1B or I-140, whatever. It's USCIS. So USCIS had a prior policy that, look, if we already gave H1B to somebody, and this person comes back for an H1B extension, okay, and there's nothing changed. The person is the same, their education is the same, the job is the same, the company is the same, they're doing the same thing. So it's simple to think, boy, let's not waste extra time. We already gave the person an H1B, let's approve the extension, right? Simple, correct? Okay? Not so simple, not anymore. Now, USCIS is going to look at the whole case all over again, and even if they approved it the first time, this time around, they may say, no, we're not going to give the respect to you of our own previous adjudication. In other words, we may have goofed up, but now it's your fault, you're going to pay. And we're going to deny the application, or we're going to send you a long RFE and make you prove the same things you proved the first time. That's how our efficient government is working, and that's how we're going to, essentially protect the US worker by making these hurdles from time to time in the immigration process. We're going to see a little more of that specifically with the executive orders, okay? BAHA. I call it BAHA. BAHA is Buy American, Hire American. Who created that executive order? Can you tell me?
Trump.
Right, Trump. Okay, so Trump created the executive order. What does BAHA say? It's specifically targeted at H1Bs. It's actually a paragraph in BAHA which says we're going to look at H1Bs particularly and at all immigration in general. Now there's a new requirement as a consequence. USCIS now requires interviews of all employment-based adjustment of status applicants. They were not interviewed before. Now all adjustment of status applicants who have an employment-based application are going to be interviewed. Not only are they going to be interviewed, they've got to file a new form, 245J, and submit that form at the time of their interview, which essentially says, I am still employed by the same company, I'm doing the same job. And then your employer has to also attest to that by signing off on the employer part of the form I-245J. Thank you. Okay, H-1B processing. What's the LCA? The LCA is a mechanism, as I said earlier, to protect the wages of the US worker. It's a proof that the employer is paying essentially what needs to be paid as a fair wage to that worker for that job in the geographic area where the employment is taking place. So for example, a software engineer in Cleveland, Ohio may be paid a very different salary from a software engineer in Silicon Valley. Okay, because of the geographic differences, the cost of living differences, things of that sort. So that is what an LCA does. The ICERT process needs to be done. And ICERT is a way that it's all streamlined now, it's all online. The LCA is actually filed online. The Department of Labor has 7 days to process and approve the LCA or deny it. They do that pretty religiously, they're very good about that. And then the LCA comes back. Once the LCA comes back, it must be included with the H-1B application to USCIS. And the employee has to be paid at least the salary that's set forth in the LCA. We're going to be seeing more and more of USCIS agents visiting the employers to make sure that an H-1B worker is actually being paid what's set forth on the LCA, that the H-1B worker is actually doing the job that is claimed on the H-1B application, and that the H-1B worker is not being treated in any way differently from a US worker doing the same job. So all of this protects essentially the US workers. Now, there's a material change in the job. Let's say the employer moves to another location, or the alien is moved from one job site to another job site. That constitutes a material change. If they're also, let's say the employer decides, okay, we're going to change the job title, or we're going to change the job duties of the alien employee, then there's a material change. Material means something of significance is happening to the job. If there's a material change, then there's a new LCA, and maybe it may even need a new or an amended petition for H-1B. Finally, the STEM OPT extension. How many of you are here who know about OPT extensions, by the way? Okay, couple of you. Now you know if you're a STEM OPT extension, what does your employer have to do?
Have to be
E-Verify. They have to register for E-Verify. E-Verify means it's a system that the federal government has set up in which an employer has to verify the employment eligibility of each and every new employee that they hire after they enter into the E-Verify agreement with the government. If the employer is not E-Verify registered, the employer cannot sign off on the STEM OPT extension. So it's very important to understand that if you're working for a company and your OPT is expiring, you've got to make sure that they are willing to register for E-Verify, because if they don't, you can't get your OPT extension. Ma'am, can you hold a question to the very end? Thank you so much, appreciate that, thank you. Okay, immigrant visas, the road to a green card. What's an immigrant visa? Immigrant visa basically is a way for someone to live and work permanently in the USA. All that we heard about so far, H1, F1, L1, O1, all that, those are non-immigrant visas. Those are visas for a specific time, for a specific purpose, for someone to come to the USA. Non-immigrant visas are short-term, they are defined for a purpose. An immigrant visa is a long-term visa, means you can live and work permanently. Once you have a green card, you can leave the job that gave you a green card and go and work for someone else. You can leave that job altogether and go and set up your own small business. Okay, you have all the flexibility in the world because now you're a permanent resident. You have a green card. Okay, so all the things we heard about were non-immigrant visas so far. Don't confuse that. We're turning the page, we've moved to a new chapter. The new chapter is immigrant visas. So why do we need another visa? Very simple. Unless you are an E1 and you're happy coasting along through life as an E1, which has no limit on how many years it can be issued. It can be issued forever till you die. Okay? Unless you're an E1, all other non-immigrant visas have an expiration date. It's like your milk. Buy your milk, you take it home. Does it last forever? No. Okay? Within a week, 2 weeks, it's gone, right? Gone bad, right? Correct? So, same thing with non-immigrant visas. After 3 years, or 2 years, or 1 year, or 7 years, whatever that case may be, that non-immigrant visa is going to expire. The person holding that visa has essentially a useless piece of paper. They've got to leave the USA. If they don't want to leave, then during that time that they had as a non-immigrant, they had better have been working on getting their immigrant status. The immigrant status is, of course, the green card. So during the time, why am I saying all this? Because I want you all to understand something. The time you have on OPT, the time you have as an H1B, the time you have as an L1, or an E1, or an R1, that's a religious worker. That time is very precious. You've got to convince your employer, if you're employed by someone, to start on the immigrant visa process. Because if you don't, that 2 years or 3 years or 5 years can go very quickly. And unless your process is in place, and unless you're close to getting your green card, you may run out of time. And that 5 years may come and you may have to leave. And if you're on an H1B and certain things haven't been done before your H1B expires, you can't extend your H1B year after year like I told you earlier. So it's very critical. Everybody, keep this in mind. There's one thing you take away from this meeting today. It is, please understand that time is limited and you've got to be very upfront with your employer. When you go to your employer and your OPT, you tell them upfront, listen, I have OPT. It's going to expire on this date. Are you willing to apply for an H1B for me? If they say, what's an H1B? We don't want to do it. There's a problem. What are you going to do? Look for another employer. Thank you, ma'am. Look for another employer. Okay? Because you only get, let's say, 1 year on your initial OPT. And if you're a STEM, yeah, you get another 2 years more. After that 3 years, what happens? The music comes to an end, right? The dance is over. Correct? So you've got to keep that in mind. Take that away from here today. Talk to your employer up front. Tell them, I need this. Are you going to do this? Yes or no? If you're not going to do it, bye-bye. Okay? Alright. We talked about immigrant categories versus non-immigrant. We're going to talk about categories of immigrant visas now, and then the routes to immigrant visas. Okay? Okay, so routes to immigrant visas, many ways. There's someone has an H-1B, maybe they get a labor certification. What's a labor certification? It's a way by which the employer tests the US labor market to make sure that there's no ready, willing, and qualified US worker who can take the job. You may be, some of you may very well be, I've done this for several Akron U students and other students at other universities. You may be an EB1, outstanding professor or researcher. You may be fantastic in your field, top of the field, okay? You may be an EB2. You may have not the same qualifications necessarily as an EB1, but you are also exceptional in your field. You've got some research, you've got some writing, you've got some theories that are going to be really important for the United States. And that could be an EB2, an alien of exceptional ability in the national interest. You can be an EB3. EB3 is someone who's a professional worker or a skilled worker. Typically, those individuals are going to need labor certification or the perm process, okay? You could be an EB5, which is an investor visa. If any of you, again, dad's willing to give you a small loan of $1 million, okay? And if you invest that money in a US enterprise and create up to 10 jobs, you can get a green card for yourself and your family. So seriously, any of you, get $1 million, are ready to make the investment, come see me. I'll help you. Okay? Alright, I'll be delighted in fact. Okay? So, but seriously though, EB5 investor visa category is a category that's being used more and more. It's actually oversubscribed right now by the Republic of China. So apparently all of you here who are from China, you're doing something right because mom and dad are giving you $1 million to invest. Okay, so come see me when the presentation is over. Alright, I'll help you. Okay, now beware of the backlogs. What's a backlog? We're going to find out in a little bit what a backlog is. Okay, how do we file? Which one are we going to select? Are we going to select perm, schedule A, EB1, 2 or 3? We got to evaluate what the qualifications are. What are your qualifications? How good really are you? Are you really exceptional? We all think we're exceptional. I think actually I think I'm fantastic. My mother doesn't think so. Mothers have a way of doing that, don't they? Okay? Alright? So I may think I'm fantastic. You may think you're fantastic. You're entitled to your opinion. You come see me. I may not think you're so fantastic. And I'll tell you that, honestly. So you've got to decide what are your qualifications. Number 2, you've got to find out what are the requirements of the job. So you find a job, you go to the employer and say, yeah, we want to hire you. These are the job requirements. Problem is, those job requirements are not professional. So you may have an MBA from this wonderful school right here, and you say, look, I got to find a job. So you run over, you find a job. It's at that fantastic institution called McDonald's. Alright? And you say, oh, I found a job at McDonald's, I am going to be a management trainee. No offense to McDonald's, no offense to the management trainees because I get food from there a lot, okay? I've got to be careful what I say about McDonald's, okay? No offense to McDonald's. But a management trainee at McDonald's does not need a master's degree, an MBA, okay? It'd be nice if you have it, sure, but it's not required. Every year McDonald's hires thousands of management trainees and trains them. Many of them may just have a high school education. So it's very important to know what the requirements are for the job because those requirements will determine if you're even qualified for an H-1B by that employer. And many employers, especially the larger employers, may not want to deal with immigration at all because they have plenty of US workers, number 1. Number 2, they may not want to spend the time and money dealing with immigration. So it's a very realistic process. You've got to assess yourself and you've got to assess the job. Number 3, you've got to find out what the salary is. If they are not going to pay you at least what's on the LCA, the labor condition application, for the prevailing wage for that position, you are not going to be able to file a LCA, you won't get an approved LCA, and you can't file an H-1B. So you've got to find out what the minimum salary is based on the prevailing wage, and then make sure the employer is paying at least that minimum salary. We're going to talk about the minimum salary too in a minute. DOL requirements. Department of Labor has requirements. Some of the requirements include, as I said, payment of the prevailing wage, posting the LCA in the workplace. The LCA is a form. The form has to be put up in the workplace. Everybody in the workplace must have a chance to see that form. Some employers may say, no, we're not putting up a form in the workplace that puts out a salary. Because anybody then can see that salary. They don't want that to happen. They don't want one management trainee to say, why are you giving that guy from India $15,000 more than you're giving me? Right? They don't want them to see that. So they may not want to put that form up in the workplace. You've got to be very careful about all these things. Okay. Processing times with the USCIS. The USCIS takes a long, long time to process applications. They're not taking premium processing for H-1Bs. So you've got to factor that into your timing as well. If you're applying for an extension, apply for the extension well before your current application, your current visa expires, so that you don't run out of time. And then finally, the priority dates and backlogs, which, believe it or not, we will be talking about in a minute. Okay, I said that to you in the last slide, and I'm saying that to you again. And I will do that. I'll prove it to you. Okay, believe me, it's going to be a beautiful thing. A simple flow chart of the EB process. So you obtain work authorized non-immigrant status. So you're an H-1B, O-1, L-1, whatever. You decide if you're going to file a PERM process or a direct I-140 process. You file the applications, either the PERM application, which is labor certification, or the I-140. Your application is approved. You then file the application for adjustment of status, which is what? What's adjustment of status? We talked about it. You get your green card. Very good. Thank you. Excellent. You get your green card. And then concurrent filing. What's concurrent filing? Concurrent filing simply means if your priority date is current, and we'll talk about that in a minute as promised. If your priority date is current, you can file for your I-140 and your green card application at the same time, and thereby save yourself many, many months or maybe many, many years of waiting. Okay, so priority dates. Here we are finally, as promised. What are they? Who sets them? Why do we need them? How does it affect an immigrant visa? How to plan around visa backlogs? The Child Status Protection Act and the H-1 visa extensions due to priority date backlogs. I'm going to talk about these last two things here real quick, okay? Child Status Protection Act. It's a wonderful act. It came into effect back in 2001, I think it was, or 2002. And essentially what it does is this. It says anyone who is a child, that is a person under the age of 21 for immigration purposes, and their application for immigrant visa has been pending for a long, long time, and they turn over 21, they become an adult for immigration purposes. Well, the time that the USCIS spent processing their application is subtracted from their age. So they may still be a child. So that's very important for some of you who may have families. Because your children are getting older every day, believe it or not. That happens to my children too. It's irritating, but it happens. Okay? So they keep on growing, they eat more, their clothes change, and they get older. So if your kids are getting older, they turn 21, they may not be able to adjust their status with you as the principal, as the parent. The Child Status Protection Act may protect them. Finally, H-1B extensions. Those are very important because if the priority date is falling behind, then you need to keep on extending your H-1B. If you're an H-1B, you've got to also keep on extending your family's visa because you don't want them, their H-4s, you don't want those H-4s to fall out of stats. Okay, let's switch. Let's go. Okay, what's a priority date? How does it affect you? Etc. So let's see. This is the priority date based on family. Could we go to the next slide, please? Thank you. I'm going to skip that slide because it's family based. Most of you are probably going to be employment based. So what's a priority date? A priority date is essentially this. Keep in mind, every year, Congress has authorized that a certain number of visas, immigrant visas, green cards, be given to people. There's a limit, however. It's not open-ended. It's not infinite. It's limited. Employment-based green cards are limited to only 140,000 a year. That's it. Okay? On top of that, every country, no country rather, can take more than 7% of the total allocated immigrant visas, whether it's for family or whether it's for employment. So think about this. You've got a line for movie tickets. Okay? Alright? And every country has its own line. But some countries have lots of people waiting in line. Other countries are smaller countries, or maybe they don't want to come to the USA, they're happy in their own country, they have less people waiting in line. Okay? Every year, there's a limit on the number of visas. Think of that limit as being the tickets in the auditorium. All of you are sitting here, there's a ticket for each of your seats. There's only so many seats in the auditorium. So every year, that line can only move by the number of seats in the theater, right? Okay, right? Everyone with me so far? So every year, so many people come, they fill up the auditorium. Great. They watch the show, which is the green card show, starring me. Okay? They leave. Next year's crowd comes in. In the meantime, however, outside the ticket window, more people have joined the line. Okay? And if more people join the line, then there are seats available in the auditorium. What happens to the line? The line gets bigger, longer. That's what's happening here. That's what's happening here. So what this means is this. Everything that is C means it's current. So for every country in the world except China, these three countries, India, Mexico, and the Philippines, everybody else is current. Because there's not enough demand for those tickets from people from those countries. Under these categories, employment made first, which is extraordinary or exceptional ability aliens, extraordinary ability aliens, professors and researchers and multinational managers. Second preference, exceptional ability aliens and aliens with advanced degrees. Third preference, professionals and skilled workers. So all those categories are current except for China, which is backlogged in the second preference to June 13, forgive me, excuse me, 1 second, sorry about that. Backlogged to 15 June of 2013, and India, which is backlogged to 8 October of 2008. We're in which year now? 2017. That's a 9-year backlog for people who are waiting in that line from India, waiting for their EB2, not even EB3, EB2. EB3 is even worse. They're backlogged to October 15, 2006. That's 11 years they're going to be waiting. In the meantime, what happens to your kids? They grow, right? Okay? So that's why the Child Status Protection Act comes in and kicks in. Also, important to know, if your visa is backlogged so far, you're on an H-1B, you're going to need to keep on extending that H-1B until you can file for adjustment of status. Correct? Okay, so keep that in mind. These are priority dates, and these dates change every month. Every month, the US Department of State publishes something called a visa bulletin. In the visa bulletin, it gives a list of the family-based petitions and the employment-based petitions and their priority dates. So if your application was filed on or before June 15, 2013, if it was filed before June 15, 2013, then and only then can you now apply for adjustment of status. If your application for a permanent visa, for example, your I-140, if it was a direct I-140, or if it was a perm application, was filed after that date, you can't file. You got to wait. In the meantime, protect your non-immigrant status. Everybody with me? It's a very technical discussion, but I want to make sure you understand. Will you keep your questions to the answer if you don't mind? Thank you so much. Okay, so that is what we are looking at in terms of priority dates. Thank you. Okay, so immigrant visas, part 1, that's a perm application. Perm application, I'm going to move over this a little bit quickly. It's the application, the basic labor certification application. Perm doesn't mean anything to do with your hair. Don't worry about that. This perm stands for Program Electronic Review and Management. It's a fancy word for saying online labor certification application. Because you know, the US government, we're very, very smart in this country, we're man on the moon. We can't do anything without an acronym, which must be many, many letters long, so that we understand, we realize how important it is and how smart we are. Okay? Good. So, consequently, with the PERM program, everything is done online, recruitment is done online. We have to prove to the US government, essentially, that everything we've done, including advertising, recruitment, was done overall, as the US government requires by the regulations, and that no ready, willing, and qualified US worker came out to take the job. And then you get labor certification. Okay, what happens with that? Once sperm is approved, you file the I-140. You can file the I-140 at any time. Once sperm is approved, that's fine. The problem is, if your priority date is not current, you can't apply for adjustment of status. Okay, if your priority date, however, is current, file for adjustment of status as well. Let's continue. Okay. Areas of extraordinary ability. You must have extraordinary ability in the sciences, arts, education, business, or athletics. You can self-petition. This is wonderful. If you have, you're a PhD student, you're absolutely exceptional. Extraordinary, in fact. You've got 10 publications. You've got 2 patents. Or you're recognized in your field. You got national awards, international awards. You may be able to self-petition. You don't need to find an employer. I've had people who have finished their PhDs, they're on their OPTs, they come to me. If they truly are extraordinary, we can file an I-140 petition for them. And the advantage, even for India and China, is in EB1 category, there is no backlog, it's current. EB1s are current. So if you're extraordinary, don't feel shy. Talk to someone. Talk to a good immigration attorney. Bring them your latest resume. Don't be afraid to show how good you are. It's a tendency of all of us as foreign students. I was a foreign student too at once upon a time, okay? It's a tendency of us to be modest. Oh, it's all my professors, it's my teachers, it's my parents, it's my, dog, my cat, everybody help me, okay? Yeah, fine, but you did the work. If you did the work, don't be afraid to take credit for it, because you might be able to get a green card out of it if you are truly extraordinary or exceptional. Okay? Alright? So don't be shy. You think I'm shy?
Yes.
So nice. Okay, good. Alright. So, give me just one quick second. Okay, you'll come to the USA to continue such work, or you're already here, you'll continue the work, and your entry to the USA will naturally, of course, benefit the USA. You file the application on form I-140. Okay. Immigrant visas. As an outstanding professor or researcher, you must have at least 2 of these, and you must be recognized internationally as outstanding. So any publication about you or by you or recognized by you in some other country, some other professors in other countries have emailed you and said, Professor, please tell us about, US immigration law, for example. Potentially, that means you're internationally recognized, because people from other countries are coming to you and saying, tell us about your work, tell us about your research, how can it help us? Okay, you collaborate, let's say, with other people. Okay, important again, as I said, you can self-petition. Thank you. Okay, multinational manager. This is very important, as I said also. If you have worked for a company for at least 1 year or the prior 3 years before you apply, and that company is a branch in the US, you may qualify as a multinational manager or executive. As a multinational manager or executive, you're also entitled to apply for a green card. So if you have that classification as an L1A, not an L1B, which is alien of specialized knowledge, an L1A, you can apply for a green card. The advantage of the EB1 category and the exceptional ability category is you skip the process of labor certification. There is no labor certification. So all those months of recruitment and expense and advertising, you don't need any of that. You go straight to the finish line, as it were. And especially if your priority date is current, the moment your I-140 is approved, you could apply for a green card, or you could even apply for a green card in conjunction with your I-140 petition. Thank you. Okay. EB2, national interest waiver. The drawback is that you must show that your work is going to be in the national interest. But if you're so exceptional and your research is so good or your work is so good, it's not going to be hard to prove that your work is going to be in the national interest. There's a case that was called New York State Department of Transportation. It was overruled by another case that came around, which is very helpful, very good for us, because now it's allowing many more people to qualify for the EB2 national interest waiver category. The current economic and political climate is a problem. We're going to look at the executive order in a little bit. Important again, you can self-petition for this type of an application. You don't need an employer. Okay. Some other categories, especially for people who are in short supply, professional nurses, licensed physical therapists, also under the Schedule A, Group 1 and 2, you can have the aliens of the exceptional ability. They are not EB2, next slide please, but very close to the EB2. They must meet at least 2 out of the 7 criteria, which are recognition, international scope and reach, and have previous exceptional work. In this category, you can also have aliens in the performing arts. So very helpful for those people who may be, let's say, exceptional dancers, things of that sort, musicians, etc., to qualify for an immigrant visa based on Schedule A, Group 2. Okay, EB5, investor visa, we talked about it. You bring either $1 million or in certain high unemployment areas, $500,000, and you create at least 10 US worker jobs. If you can do that, then you get a conditional green card, good for 2 years. You've got to then prove to the USCIS that, look, our business is still going on, we're paying taxes, we're hiring these people, we've created so many jobs, therefore give us a permanent green card, and you get that. It is not, however, keep this in mind, it is not the same as the non-immigrant e-visa status. That's different. That's a non-immigrant status. That's good indefinitely. It doesn't require $1 million, doesn't require to create 10 jobs, but it's a non-immigrant status. That's the E status. The EB5 status is the investor visa, $1 million visa. Okay, thank you. Okay, some of the statistics on how wonderful immigrants are in terms of creating jobs, setting up businesses, things like that. Among people with advanced degrees, immigrants are 3 times more likely to file patents than US-born citizens. That also means that if they're filing patents, they may be obviously very creative people, they may go out there, they may start their own businesses. Same thing in the top quotation. Immigrants are more than twice as likely to start businesses each month than were the native born in 2010. Okay, so what has come out of the White House since the inauguration? A lot of stuff has come out of the White House. Okay, and we won't comment on what has come out or the quality of what has come out. This is not the place for it. But what is important for us in the immigration field is the Buy American, Hire American Executive Order of April 18, 2017. Why? Because it's put a serious wrinkle in the employment-based non-immigrant and immigrant processes. The executive order is being implemented by the USCIS in all employment-based applications, and specific portion of the executive order actually restrict H-1B workers. Let's look at what the executive order says. Section 5 says that the executive order is going to be used to direct the Secretary of Homeland Security to protect the interests of United States workers in the administration of our immigration system, including through the prevention of fraud or abuse. In other words, everything the US government can do to make sure that fraud and abuse are not happening, they will do. What does that mean? Double checking, triple checking, asking questions that have already been answered, sending out more agents to the field to check on what's happening at the employer. All those things are going to slow things down. Let's continue, please. With the H-1B specifically, what are they going to do? They're going to reform. I don't know what they can reform in the H-1B process, okay? Our First Lady came to this country as an H-1B, all right? But now she's here and we're going to reform the process, okay? What are we going to do with the reformation? Ensure that H-1B visas are awarded to the most skilled or highest paid petition beneficiaries. What does that mean? That means if you don't have an advanced degree, if you don't have a higher paying job, more than what the basic LCA prevailing wage is, you're most likely not going to get an H-1B. And we, as practicing attorneys, have seen that this year with extraordinary numbers of H-1Bs being returned for requests for evidence to prove that individuals who are seeking H-1B category classification and are being paid the lowest prevailing wage are indeed truly quote-unquote professionals for the regulation. So all of this is really, really chilling the H-1B category. So much so that here's my advice. It means the standard of review will be much higher. It means the entry-level worker at the level 1 age will probably not qualify for H-1B. it means that only very highly skilled workers are going to qualify. So either level 2 or higher. So what am I advising my clients? Prove that your abilities and the quality of your work must be at a sustained high level. Number 2, if you're applying for an H-1B, you must have more than a level 1 prevailing wage. Number 3, if you're applying for an H-1B, the job description and requirements must be higher than for an entry-level position. And I know this is very technical to you, you don't know what these terms mean, but essentially the US government has something called a SOC code, and it's listed also on the ONET, which is a publication of the US government on the web. You can go to the web, you can search for O*net, and you will find various job descriptions of various occupations on that ONET. If your job that you're going to take up with the employer is not a higher level job, at least a level 2 or level 3 wage, you're probably going to have your H-1B application rejected by USCIS. Finally, keep in mind, for anyone who is a employment-based applicant for adjustment of status, they're going to be interviewed and they're going to have to fill out form 245J and submit it to the USCIS. Okay, questions and answers. Right at 4:30, so I did pretty well. Questions and answers. Let's take a few questions and answers. And we've got, as I said, experts from our International Student Office as well here to help out with questions on OPT, CPT, etc. Sir?
When is the best time to apply for the EB2 National Interest Waiver?
Well, the question is this: what is the best time to apply for EB2 National Interest Waiver? There is no best time. In my opinion, the sooner you start, the better, because everything in USCIS is taking a lot longer time now. So you're better off evaluating your case, see if you qualify, and then applying for it. There's really no best time. I personally think that it's better to do it sooner rather than later. We have rules in place right now. We do not know what the executive order is going to do with those rules. It may change it altogether. It may make it much more difficult. Okay? Now I know we have 2 questions. I'll take you first, ma'am, and I'll take you, sir. Okay? Ma'am.
Please, I didn't understand exactly the child abuse thing that you said. The time stops and they start counting even if he is over 21?
Correct. You're talking about the Child Status Protection Act. So under the Child Status Protection Act, what that means is essentially that a child is someone who is under 21 for immigration purposes, okay? Not 18. For immigration, a child is 21 or less, essentially. So once a child turns 21, they're no longer a child. If they become an adult, they can't come with their parents. So let's say one of you has a child, okay? You're a family, all right? And you have a number of children, and your eldest child is 20 years old, and you apply for your green card. And that's great, because your child is under 20 years old. Apply for a green card. But, however, because of the backlogs, you can't file that petition until after your child has turned 21. Now, because your I-140 petition, let's say, took 2 years to process, okay? That 2 years is going to be subtracted from your child's age. So if your child is now 22, you subtract 2, your child goes back to being 20. Your child is eligible to emigrate with you as a child. You understand? Okay? Sir?
I have 3 questions. Can I ask you a question?
I don't think we can ask 3. Let's ask 1 and then we can go to someone else, because I need to be fair to everybody. Okay? Thank you.
So you said that different priority dates. So for the EB2, it is like somewhere 2008 for Indians. So if I suppose get an my H-1B today and I can extend I get for 3 years and then I can extend for another 3 years, 6 years. Let's consider my OPT also for 2 years. So total 8 years. So altogether I have 8 years. So if I apply today, considering the rate it's going on, so it should be, by next 8 years, I'll be out of status, and by that time the priority date will go to 2060, and now I'm applying on 2017. So what will be my status then?
You have to then apply for a continuation of your H-1B. After 6 years of H-1B, as long as your application for PERM, which is the labor certification, or the I-140 has been pending for more than 1 year, and there's not been a adjudication of that application, you can extend your H-1B. You can also extend your H-1B in cases of countries which have a high backlog, like India or China, and there's no visa available. You can extend your H-1B as well in those cases. So in your case, if you are from India, which I suspect you are because you're asking me that question, right? Are you from India, sir? Okay, you are from India. If you, let's say, start your application process today, and we know it's going to be an 8-year wait. You start your process today, you are going to be fine, because if your I-140 is approved, but you still can't apply for your green card because of the backlog, you would just keep on extending your H-1B. So you will be fine, and your spouse, dependents, if you have any, they will be fine as well. Their H-4 will continue to be extended.
So I-140 has to be approved within this 8 years period.
The I-140 either has to be approved or it has to have been filed and pending for 1 year or more. Same for the perm application. If it's filed and pending for 1 year or more, then you can extend your H-1B beyond the 6-year period. Okay? All right. Sir?
Can I start my own business like an LLC if I don't get unemployment?
That's a great question. His question is this, and it's a very tricky question. And I've advised people on this. His question is, if I don't get employment and I'm on my F1 visa and my F1 is over and I'm now on my CPT, let's say, OPT, can I start my own business because I can't find an employer? That's a great question. I would say to you cautiously, yes. I've actually got an article on my blog on that very topic, so go ahead and read it. Okay? But every case is different. You've got to be very careful on how you tread this water. It can be very calm, it can be very, very easy for you, it can be very helpful to you, but there also can be various dangers when you get into that water. And you've got to be very careful so that you steer yourself just right so you don't fall off a cliff into the bottomless abyss. Okay? Into the, what's the deepest one in the ocean, in the Pacific Ocean? The Marianas Trench. 36,000 feet or something. The whole of Mount Everest would fit into the Marianas Trench. You couldn't even see it. There'd be still space left to spare. Incredible. Okay, next question.
I didn't complete it.
You didn't complete the question! And I'm on the Marianas Trench already. Go ahead. It's a very deep question, you can see. Okay? Go ahead.
Okay. If I go for another master's, if I don't get
Yes.
a job and I start another program, probably a PhD,
Okay.
can I still look for a job and get a job based on the initial master's?
Absolutely, absolutely. The question is, if I can't get a job on the initial master's and I go for a PhD, can I still apply for a job on the initial master's? Absolutely, you can. If you have you can apply for an H-1B each and every year. If you've got an employer and they're willing to spend the money and the filing fee, absolutely, you can apply for that and use the education you have or the experience you have up to that point. Absolutely. Any other questions, sir?
I'm from Bangladesh, and as far as I know, the EB2 for my country is current.
Correct, right.
If I apply for EB2, will it also apply for my wife?
Absolutely. If your wife is from the same country, then absolutely. If your wife is from a different country, and here's the interesting part, that's a great question. I just did a case like this. Imagine this, your wife is from a country which is backlogged. Let's say your wife is from India. Okay, and she's working as well, she has a job as well, her employer's already done an application for her, but she's waiting for 8 years. She's going to wait for 8 years, okay? Because your priority date is current, you're married to your wife, when you adjust your status, the law allows your spouse and children to also adjust their status, even though their priority date may be a different date which is backlogged. They piggyback on your priority date.
It doesn't matter whichever visa she is in.
Doesn't matter, correct. She would be able to adjust status. As long as she's in status, that's the key point. You've got to keep the dependents in status. Okay? Alright. Any other questions? Sir, you had another question. You're just brimming with questions. So here's your chance for a second bite of the apple.
Say the EB2 and EB2 NIW have the same priority dates.
Say again.
EB2 and
Oh yes, they have the same priority. Correct. Okay. And that was a very fast and very easy question. So let's move on to question number 3.
How difficult, suppose I get a job at employer X and it's not e-verified, so how difficult is for an employer to e-verify itself?
You can't e-verify yourself. You've got to actually go online and commit to memorandums of understanding with the U.S. Department of U.S. Citizenship and Immigration Services, and if once they approve it, then the employer can start doing e-verify, and they will be certified as e-verify, so then they can extend your OPT. So it's not difficult. I've done that for employers.
Yeah, because I've seen some YouTube videos and it says that it's not the PR job.
All right. It is not or it is.
It is not.
It is not right. I didn't say it's illegal. I think you know. I mean, it's like any other government process. There's forms, there's paperwork, and then there's more forms and more paperwork. But you get it done.
So the employer has to spend some money on that because most of the employer doesn't want to do it.
Well, if they, you know, honestly, that I can't tell you, sir. That depends on how they want to do it. Some employers will do it themselves in-house if they have a HR department. Some employers may not want to mess with it. They may have had employers pay me to do it for them, and that's fine. Okay, so it depends on the employer. Young lady, you had a question?
Yeah, for the EB one, is it really 10 papers for PhD? Like,
Just joking, I'm looking at your style. Okay. No. There's no number. There's no magic number. Ladies and gentlemen.
How do they evaluate?
That's a great question. There's a lot of things, a lot of factors that go into EB1 determination, including not only the quality of your papers or the number of your papers, but where were those papers published? What's the impact factor of the journals in which they were published? How many citations resulted from each of your papers? Were those citations only in local domestic journals, or were the citations also international? So when I create an EB1 packet, my packet is like a telephone directory. You know what a telephone directory is, anybody? Anybody remember those? Okay. My packet is like literally like a telephone directory. We're looking at literally dozens and dozens of articles, citations to those articles, emails from professors overseas or researchers overseas saying, hey, this was a great paper, can you collaborate with us on something else? Come and give a presentation at our university based on your things of that sort. You've got to, like I said earlier, what did I say earlier? I said, don't be shy. That's right. Don't be shy. Okay? Yes.
Another question?
Yes.
For the national interest EB2 category, can it be something we are working with the government? Or
Absolutely.
It's just your project. I'm going to graduate.
It can't be that by itself. But imagine that it has significant, let's say, what field are you in?
I'm in natural resources,
Okay, environment. Okay, so you're figuring out ways to, rape the earth and get more fossil fuels out.
Remediation.
Okay, or you're doing remediation. Okay, fine. So going to fix the problems that have been caused by fossil fuel extraction. Okay, right? Something to that. So, yes, if it is something that can be shown to be in the national interest, not only in your case, not just national. In your case, I'd argue it's international, because you want to fix. And fixing is not just in the US, fixing is in the whole world, right? Okay, so I think absolutely. I would not neglect anything. Ladies and gentlemen, I would not neglect anything. A good lawyer is going to look at your entire collection of work and is going to find that hook. We need that hook, right? We want to throw that fishing line and we want to reel in the USCIS adjudication, right? Isn't that what we want to do? You want to bring them in, right? How do you bring them in? Not by giving them some boring story. I was born in Mumbai, India, and I came over when I was a little child. No! We want to show them, how do you fix the scars left on the earth by open cast mining? Right? That's what you do. Excellent. So how do we fix those scars? How do we heal the world? How do we make it a better place? Okay, make it a place for you and for me and the entire human race. How do we do that? Okay, what else? One or two more questions, let me wrap it up. Yes, sir.
So perhaps you've applied for an NIW and then you place the application's pending, and then you later get a job, and then you put in an application for getting your green card. Is that going to undermine your application?
No, that's a great question. You can file multiple applications. I've done applications for people simultaneously in EB1 and EB2. Why? If one fails, you've got a good chance the other one will succeed. In fact, I've had, believe it or not, I've had EB2 applications being denied, which is a lower standard, and I've had EB1 applications for the same person being approved. I'm not kidding you. Okay, so yes, you can, and in my opinion, sir, you should. If there's a way to do multiple applications, do them. It's an insurance policy, right?
So
If one fails,
no problem if you ever had a denial and then you go through it again?
not the same one. He's saying there's two different categories altogether. He's doing one, let's say, NIW, and one a typical perm process. let's say, okay? You can do both.
But what if the same status?
You can do this. You can do the same application again. Let's say this year you did an IW. It got denied because you weren't exceptional enough.
Okay.
Next year you do something really exceptional. Okay? You go to law school. You become a lawyer.
So
Okay?
there's no problem if you
You can apply again. Absolutely. Okay. Any final question before we wrap up? One last one. Yes, Henry.
Can you apply for the US visa lottery at the same time?
Absolutely you can. Now here's the problem. Here's the problem I will tell you with the visa lottery issues. The visa, when you apply for a visa lottery, you're actually typically applying for an immigrant visa. That means that potentially you've applied for an immigrant visa. That may be a bar later on if you leave the USA and want to come back because you've expressed your immigrant intent by applying for that visa lottery. So that's in my opinion, that's a difficult question. That's something that you want to consider carefully before you apply. If you're not going to leave for a long time and you have other options lined up, yeah, maybe apply. But if you think you're going to be leaving, in order to come back you need a visa, that might put a problem for you. Would you agree with me on that issue, ladies, on the visa lottery, the diversity visa lottery? Would you agree on that?
Yeah, I mean, I think it's unclear how that's going to
Yeah,
affect a
that's right.
non-immigrant visa application.
Right.
So cautionarily, maybe don't apply unless you know for sure you really are going to
Right.
save yourself.
Thank you, I
But
appreciate
no problem
that.
if
Yeah,
you know, but no problem if you know that if you know that you remain in the United States.
correct,
And you don't even want to leave the United States.
correct,
So no problem if you apply for the.
correct. Diversity visa lottery, yeah, there's no problem, no problem.
But can you apply at the same time, or for example, a few months later, the visa lottery then that you do?
Absolutely, there is no bar on multiple visa applications in multiple grounds. There is no bar on that. But just keep in mind that once you apply for an immigrant visa, you've established immigrant intent. If you leave the USA and you need a visa to come back, you may not get that visa because you have applied for an immigrant visa in the past. Okay? Yes, ma'am.
What about the students that apply for OPT or STEM center after they apply for an immigrant visa? Should that be-
That's a great question because under that category, in my opinion, in that case, as an F1, as you know, you've got to have non-immigrant intent. If you've applied for an immigrant visa and then you're applying for an OPT extension, clearly you violated that issue of non-immigrant intent. You clearly established immigrant intent. I think you have a problem. USCIS may potentially turn around and deny that application in that case. It may. But keep in mind this function too. The USCIS is only adjudicating, and this is a fine point of law, is adjudicating applications filed within the USA. It's not adjudicating applications for visas. It's not adjudicating applications for entry to the USA. Those people are already here. They've already entered. So my argument as a lawyer would be, they've never left. They don't need a visa. Okay? So in that case, you shouldn't be considering whether or not they apply for an immigrant visa or not. Because they're not seeking entry to the USA from overseas, from another country. They're in the USA, they're simply seeking a change of status. Okay? That's the way I would, because honestly, what is immigrant intent and non-immigrant intent? It's the deliberation by the consular officer at the consulate overseas to allow or disallow a person's application for a visa to enter the USA, because that person's not in the US. Right?
Well, I thought maybe USCIS also looked at that question.
They might, but the fact of the matter is, I don't think that the law, my argument would be, the law doesn't apply. Because you're not issuing a visa, you're simply issuing a change of status or an adjustment of status to someone who's already here. If you defer, email me. If you have other authority on the subject, please email me. I'd like to, stand corrected. Any final questions before we wrap up? You've been a great audience. I have some of my business cards. If anybody wants a business card, come on up and take it. I'll be happy to give it to you. If you have any questions, email me. And if you think you're qualified, if you're an EB1, EB2, as I said, can you advance the slide one more, please? If you're EB1 or EB2, you don't need to worry about essentially being shy. Put together a good resume, talk to someone, evaluate your case, okay? All right? So, anybody want a business card? Sure.
Thank you guys.
You're welcome. Thank you
So
all.
anyone in a residency for the event, please sign on this here because
website or post any information.
Very nice. You did all that yourself? That's came with the book.
Oh, yeah, I thought
I thought you did that.